Good morning, everyone. I'm Javier as part of the EUIPO Academy team in charge of the webinars. We are glad to be here. Today, our topic is business, smart IP investments in Africa. All over the world, to develop an IP strategy or to protect your IP anywhere means cost, translations, and documents. Contrary to what we can hear every time after our today's webinar, you will be able to draw your own conclusions on the fact that it's worth to file in Africa. I shall recall you that EUIPO has an Africa IP SME Helpdesk to provide you with personalized and confidential help. The 6 helpdesks and all the others existing and successful initiatives of the European Commission, this time implemented by the EUIPO under the AfrIPI project. Likewise, we would like you to be aware that there is a EUIPO SME Fund 2022 available since yesterday, and please, for further information, have a look at the EUIPO webpage. Well, going back to the helpdesk, it is oriented to the EU SMEs to raise awareness of the IP protection in Africa. We have a website where you can find materials. We organize trainings designed particularly to the EU SMEs, and we also give tailored advice on IP-related matters to the EU SMEs through our helpline service. EU SMEs can call us, send us an email, or get one-to-one consultations during our events. This all free of charge and in jargon-free practical information. Today, we have with us 2 excellent speakers, Nancy SAMURIWO and BEBEY, ABONG, who are the best placed to share with us an overview of the IP system in Africa and some tips to make smart choices when facing an IP strategy in Africa. And let's give the floor to Nancy SAMURIWO, who will start sharing with us this knowledge and some tips to understand better how to face this IP strategy in Africa. Please, Nancy, go ahead.
Thank you, Javier, and welcome everybody. Thank you so much for being with us. As I'm beginning to share my screen, I'll tell you a story. The year was 1986. I was young, and there was a song. The song was by Tina Turner, and it went on to become a very big hit. In her song, she asked, "What's love got to do with it?" Today, I hope we can ask the question, what has Africa got to do with IP? And for businesses, please stay with us, because I would like us at the end of this session to then sing along with Tina Turner and celebrate Africa and say, Africa has everything to do with IP. Please stay with us. I will share my presentation with you. The first slide is about my name. I tried to be African today by putting on a turban, but my biggest regret has always been about my name. Most of the people that I interact with expect me to be Japanese because of SAMURIWO, which sounds like samurai. Or they don't expect me to be African because I'm called Nancy. I sincerely wish that I was called Ngobile Kokozolo. I wonder whether you can repeat that. Ngobile Kokozolo, the click sound from Africa. But without further ado, to just warm up our presentation, I will be just discussing business smart IP investments in Africa. The structure of the presentation is as follows. There will be the presentation, but because this is a webinar, please feel free to engage freely, stop me, don't shout at me. I will use slides, but I think Javier will also help me to see you as you raise any questions. Please also feel free to share what you have to share. The first parts of my presentation will be focusing on Africa. The first section will be about Africa, the facts. Then Africa, the business overview. Then just an overview of the IP systems. Then after that, my part 4 will be dealing with smartness. We go smart. Smart IP searches, smart choices, smart designations. So we will definitely try to be smart. So without further ado, I'll now turn to Africa, the facts, my motherland. There's the map of Africa, and it's deliberately colorful because in Africa, we are like a variegated leaf, colorful, bright, in your face, loud, welcoming, friendly. So I'm quite proud of that, our African perspective. Africa is often called Mama Africa. And nobody ever calls Africa in terms of the male gender. And I think there's a reason there. I tried to emulate my picture by also putting on a turban. But we are called Mama Africa for a specific reason. Scientifically, we are the origin of mankind, but we also rich for IP. We've got a rich history, cultures, economies, resources, languages. So for IP, I would summarize Africa as being abundant in terms of any IP that you can think of. We're also a balanced continent. I don't know whether many of us know this, but the length and breadth of Africa are exactly the same. I don't know how that was, but it is about balance. So you will find the need to balance your interest in Africa as we go along. An interesting perspective that I will share is about Africa being fast. We are the fastest growing continent, fastest in terms of population, fastest in terms of technology, fast in terms of our animals. So for instance, if I were to ask you a question, which animal found in Africa is the fastest in the world? The leopard, the jaguar, some people pronounce it jaguar or jaga, but it's jaguar. The cheetah, not the cheat. I'll get back to this point. So I think I like to put Africa in the same category as a cheetah. It is fast growing, and the history is held by Sarah, an African-American cheetah that was based in Cincinnati in the zoo. She was aged 11, and she had an astronomical 96.5 kilometers an hour. That was twice the speed of Usain Bolt. So this is the lightning speed that perhaps, businesses should be thinking of when they come to Africa. That is the cheetah, part of the cat family. It is different from a leopard. I don't know about you, but all the pictures I see of leopards, it's either they are resting or they are just, inclining. But the cheetah is always in action, deliberately so. So what is it about Africa and the cheetah that we recommend? Africa cheetah traits, agility. You have to know your Africa, which states are first to file. You really have to move like a cheetah. Celerity, dexterity, flexibility, all these letters, it's lit in Africa. And for your brand, or for your IP, especially if it is trademarks, there's that lovability element. You have to adapt so that you're lovable in Africa. So these are the characteristics that I kind of draw from the cheetah. Moving on to business, I love Shakespeare, although he's dead. And strangely, I love the tragedies more than the comedies. I love Hamlet, Othello, Julius Caesar, but Macbeth. But one of the most famous quotations from Shakespeare is from William's Hamlet. To be or not to be? That is the question. Hamlet was talking about life and death, about whether to live or die in that famous soliloquy. But what are the implications for business today? I do believe that they do take us back to Hamlet. And the question that we always have to ask ourselves is, to be or not to be in Africa? Is that really a question? Is it? Really? Now? I think not. But let me take you on a journey. Why should you be in Africa? Population. We are young, we are growing. That means we've got a significant market. We are the fastest growing urban population and fastest growing young population. So that means you've got a tech-savvy market waiting for you. Growing IP awareness and enforcement in Africa. We are moving up. We are rising. Yes, we have our stories on enforcement, but there's a lot which my brother Blaise will talk to you about. By the way, as a secret, in Africa, we're all related. We seldom, refer to each other as a colleague. So Blaise is my brother, but he will take you through some of the initiatives that, are happening in Africa in terms of improving enforcement of your IP rights in Africa. What else is happening in Africa? Improving governance. I know Africa has always been dogged by corruption, by sadness, by bad news, but I think one by one, bit by bit, all of Africa is beginning to understand and appreciate the importance of embracing good governance. We're moving up. We've got new leaders, and we're forced by their own nations to be accountable. But if not, on the global scale, they're also forced to be internationally accountable, and that is good for IP. We also have the closing tech gap. The young population is very much, conversant of technology. Mobile penetration is one of the fastest in the world. We've got also the collapsing political borders, the African Continental Free Trade Agreement being just one of them. So very soon, you'll have a huge market, which is full of single countries, but each working together, one in oneness. So it simply means we are unique, but we are all together. This is what you find in Africa. We've got mining and horticulture. By the way, in terms of diamonds and gold, Africa produces 50% of the world's diamonds and gold, and the rest of the world produces the other 50. We've got horticulture, we've got tourism. I think by now you know because it is reclining. That is a leopard, it's not a cheetah. We've got agriculture. So there's quite a lot that is going on in Africa. So I think at the end of it, for businesses, especially, coming to Africa, where there is opportunities to grow your capital, the question then, when you go back to Shakespeare and Hamlet, I put it to you that the question is now not to invest in IP in Africa is not really a business smart option. It's no longer to be or not to be, but it has to be. You have to be here to be business smart. Africa has got 3 generic IP systems that I will talk about. We've got ARIPO, which is the African Regional Intellectual Property Organization based in Harare, Zimbabwe, where I am based. We've got OAPI. I will not preempt my brother Blaise. You will talk to you about the Francophone version of it. Then we've got own territories. But the interesting fact is ARIPO has now 21 member states. OAPI has 17. Mathematically, we've got 38 countries out of 54 African countries. That makes about 70% plus of Africa belonging to regional intellectual property organizations. That has advantages. Oh, how so? So for example, for ARIPO, which its 2-letter word is AP, that's their logo. We've got member states that are using one complementary system. When we say complementary, unlike what my brother Blaise will talk about, ARIPO system does not replace national laws. Each country retains its own autonomy. But we use one language, which is English. So it means you don't really have to fluff around getting notarizations, getting translations. The ARIPO system is simple, clean, and methodical. ARIPO has got 21 member states currently, soon to be 22. There is a West African country that is really in the process of acceding to the ARIPO protocols. And out of these 21 countries, 18 of the member states belong to the Harare Protocol, so that you're able to protect your patent, utility model, and industrial design by picking out of the 18 states, which I'll talk about later. And for the trademark system, there are 12 of the countries. Which are these countries? The 18 Harare Protocol states, I've listed them there in terms of their 2-letter codes, but what is probably interesting to know are the exceptions, which are the 3. Mauritius, SC is Seychelles, which recently joined, and Swaton, Somalia. So the rest you can designate in a patent, utility model, and industrial design application. For the 12 countries that form the Banjul Protocol, which is the ARIPO trademark system protocol, you've got 12 countries to choose. So that makes it easier. Instead of going from country to country, at least in Africa, when you're looking at ARIPO, you've got something to start from. So I did mention that under OAPI, my brother Blaise will talk about that. I did mention that OAPI plus ARIPO, you've got 38 out of 54 states, which mathematically takes you to above 70%. So that makes it easier for EU businesses to be in Africa, and it's easier to coordinate. But for those that are not part of the ARIPO system, they've got their own national systems, and you've got big economies, Nigeria, South Africa, Angola, you can still protect in those countries. In terms of the strategy, we'll talk about this in a moment. So how smart can we be when we are in Africa? What are we talking about? I'll talk about smart IP searches, choices, and smart designations. Smart, what do we mean? When I was preparing this PPT, I saw two dimensional aspects to smartness. As an acronym and as a word. As an acronym, it stands for specific, measurable, achievable, realistic, and timely IP inventions. So SMART can be used as a goal setting for IP goals. But as a word, SMART, when somebody says you're smart, you're shrewd, discerning, insightful, wise. I say discerning twice because you have to be doubly discerning in Africa. So gone are the days where I would say in Africa, in terms of, choosing where to be would be a matter of dice, not dice, but strategy. What is strategy and what does it entail? To me, I think strategy comprises three things. Think outside the box, plan ahead, manage your rights effectively. So again, we go back to the cheetah traits, agility, first to file state, celerity, dexterity, one-in-oneness, flexibility, lovability. So have a strategy around these things and see how that works out for you. So when you're now choosing smart state designations, remember I did say in ARIPO, you can choose states. It's an a la carte kind of system. So how do you choose is a question that often people ask. I found it easier to explain what I call the concentric circle strategy. By the way, I was bad in maths. So whatever principle I caught in maths, I made sure that I caught it very well. So for me, concentric circle is really starting with the nucleus and going out. So mathematically, there's a definition there, two or more circles which have the same center point. So your strategy should start from somewhere which is centered and it involves everything else. So for me, using the concentric circle theory, you start with your nucleus, which is the crown of the jewel. Which African state or states do you want to be? Then you have the ripple effects, and see how else you want to go. I will demonstrate this and explain how it works out. Say, for instance, Zimbabwe is your target market. So I would put my jar in the center, and that is my crown. The ripples in terms of cross-border spillover trading, where you'll be concerned with enforcement issues will be Botswana, Namibia, Malawi, because they just border Zimbabwe. So I would use the ripples. So it starts from the center, then you go out. Then again with the red and the blue. Remember, some countries are first to file, and some countries you file on the basis of actual use, and some you can use later. I like to mix them and then use the ones that you actually need now. These are the red ones. The ones that you might need tomorrow in terms of your strategy, your vision, your product line, then these are the blue. So you balance them out and you start from the nucleus and you go out. ARIPO allows you the flexibility to mix and match your countries, as I will show just now. But once you've selected your countries, I recommend that you start with smart IP searches. It's always good to know what is out there and see how you can overcome any challenges that you're likely to face. Then smart state designations. You can choose states You can also choose classes. Most people tend to think that if you make designations, you should then have the same description of goods for each of the same states. No, pleasantly so. Because, for example, if you want to protect your trademark in West Africa, in Liberia, which is part of the trademark system, you might find that some of the goods and services that you're offering in Liberia have no relevance to Zimbabwe. So tailor-make your specifications so that they relate to the actual jurisdiction that you want. So in terms of the designations, I was just reminding you there that, for patents, you've got, the 21, 18, 12 rule, know your states. Most people will say for a patent application, designate all ARIPO member states, and they get very upset when you designate 18 instead of 21. Or they'll say for the trademark system, they expect all the 18. So let's just know how we do this. And we remain flexible, like I said, find goods, find states that make sense in terms of your strategy. Be relevant. Let's keep track once we're in the market and see what it is that we're doing, what the competition is doing. Like I said, Africa is about cheetah, about being fast. Let's do that. Be flexible also. It means the ARIPO system, you can actually add and subtract, states. So I think it's a good thing because you can start with one and build up. Or you can start with more, and as the economy makes it difficult or as the market fails to perform, you can reduce your states. And this applies both to patents, trademarks, and designs under the ARIPO protocol, and also for trademarks under the Banjul protocol. Designations, I've already mentioned the need to be specific and to tailor-make them to suit your strategy. Add, reduce classes. Have smart choices. You have to invest in reputable lawyers who can handle your IP. I think partnerships are important. In ARIPO, you will find that if you go to the ARIPO website, you are able to actually get a list of accredited IP lawyers. So you need, because you're not going to be physically present in these jurisdictions, you need a smart, legal system that backs you and a competent, a group or single lawyer that will guide you. The aim always is to avoid dealing with fly-by-night agents. How do you tell a fly-by-night agent from one? Easy. I think personally, if I'm going to be riding on a broomstick, choose the bigger lawyers. I'm just joking. Choose the bigger lawyers like me. There's no way I'm going to fly on that broomstick without breaking it. But anyway, the point is, let's be smart as we choose our lawyers. So to conclude, in Africa, I would say, I like inventing words. Practice, to be business smart, practice what I call IP Nostra Boom. And it's just an invented word. Nostra Boom, starting from know your market, strategize your approach, build enduring relationships. Chinua Achebe famously said, if you want to go far, you have to go with other people. So you have to build enduring relationships. They move like a cheetah, not a cheetah. So to summarize it, in Africa, we're very musical. I came up with this one and I said, no. So you go up, know your market, strategize, you go around like a python, build enduring relationships. They move like a cheetah. Then you've got your Nostra Boom approach to IP. So without further ado, I'll just wait for you and let me know whether you've got any questions on what I have said. Thank you. Otherwise, I will say thank you very much. Again, my name is Nancy, not Nobile Tutozolo, but it's Nancy SAMURIWO, and thank you so much for your attention.
First of all, I would like to thank you for the lessons we have learned from you about how to understand this approach to IP in Africa and the flow and the spirit you gave to your presentation. Thank you very much indeed. And now what we can do is that we will give the floor to Blaise, and we keep the last part of our webinar for the questions of the audience. Okay, so maybe Blaise, I don't know if you are ready to share your PPT.
Yes, I'm doing that.
Okay, so go ahead, please.
Okay, so Thank you, Javier, for giving the floor. Thank you for moderating this dialogue. I also want to thank Nancy for her wonderful presentation. It actually helps me to go ahead because I just go to the details concerning OAPI. I also want to welcome our attendees for joining us. I hope that at the end of our presentations, you are able to have information that is critical about how to enter the African market. So my presentation is basically going to discuss how to leverage intellectual property protection for market access in the OAPI region. So what do we aim to achieve this discussion? First of all, you need to know what is the OAPI IP landscape. OAPI stands for Organisation Africaine de la Propriété Intellectuelle, which is the African Intellectual Property Organization in English. And it brings together 17 African countries. And our presentation is going to aim also to provide you with useful information on how to guarantee legal and commercial protection. And finally, I'm going to share a few tips and also discuss some common pitfalls that are related to IP when you intend to enter this market. So I'm going to give you a brief overview. I discuss some of the efforts that have been made to have a single market system in the OAPI region, definitely on how OAPI integrates into the EUIPO and global protection system, and then useful tips. But what is OAPI? Like I said, OAPI is the African Intellectual Property Organization. It brings together 17 countries and was created in 1977 by the Bangui Agreement. When I go into details here, you're going to see what this is about exactly. So the organization seeks to do a couple of things, but most importantly, the difference you're going to find out from the presentation that Nancy, my sister Nancy, made is that with OAPI, we now have a harmonized and single IP legal system. So you don't have the complementarity that you have in the ARIPO system. We have a single system for 17 countries, and this single system serves as the national ensemble of IP laws in all of the 17 countries. That is the main difference between OAPI and the Bangui Agreement, which is the single law, provides both for industrial property on one hand, patents, trademarks, commercial names, and for artistic and literary rights on the other hand. So let's look at the map. When you look at the map there, you see, so most of these countries, I think all of OAPI countries are French speaking. So you have 17 countries spread around Central Africa, West Africa, and then you have right down here on the Indian Ocean next to Madagascar, you have the Comoros Islands, which are part of OAPI. When you look in the middle, you see, I think Nigeria is not part of OAPI, but surrounded by OAPI countries. And the OAPI countries bring together a market of about 220 million people. Well, Nigeria alone has about 250 million people. So it could be very strategic to have Nigeria in this position. Why not Nigeria joining OAPI in something? Well, it's still wishful thinking for now. We could make the OAPI market to explode. And I want to state that if you look at the countries, you see that some of these countries that have actually made huge improvements on governance, Cote d'Ivoire, Senegal, Togo, Cameroon, Gabon, which are actually very attractive for business. Maybe some of you have already had the opportunity to do business in these countries. You can rate that they're actually being applauded for the efforts that are being made to attract investments and to have a business-friendly climate. So how come we have 17 countries across that are using the same single IP system? One thing you must understand is that these countries were all former colonies of France. And before independence in 1960, they were all using the French IP law, the French IP system. You would understand that there are huge similarities between the Bangui Agreement, which was entered in 1977, and the core concepts of French IP law. Well, those are legacies of colonialism that we are dealing with. But I think that the advantage is that it was able to bring together a number of countries who have a common agreement on IP and have common strategies in order to push forward the respect for intellectual property law across the region. I think that is a big advantage. So what does this single legal system aim to do? What basically is the goal of having a single system? One, it establishes a regional organization. So OAPI is the organization that is responsible for centralizing, filing, registration, publication, and even the follow-up and sustenance of rights. OAPI is based, the headquarters of OAPI is based in Cameroon, where I'm actually doing this presentation from OAPI headquarters, because OAPI is hosting our AfrIPI project, which is a critical partner of the EU in pushing forward IP on the continent. So OAPI is a single body. On the other hand, the Bangui Agreement serves as the single national law on IP for all 17 countries. So all of these countries have agreed to replace their national IP legal system with the Bangui Agreement. And so titles, subjects, rights that are guaranteed in one country are considered to be guaranteed all over the region. The same for industrial property rights, but a little bit different for copyrights, artistic rights, because the law gives the ability for each country to have a collective management organization, a CMO, in their respective countries to deal with issues related to copyrights. So globally speaking, the Bangui Agreement provides a single system for patents, utility models, trademarks, industrial designs. You have trade names and even geographical indications, plant varieties, literary and aesthetic property, and then the protection against unfair competition. So it's the biggest, with the revision in 2015, Bangui Agreement covers all aspects of intellectual property rights and provides a single system of how these are enforced and managed, and how all actors within these countries can apply to the OAPI system to be fully protected. That is the strength of the Bangui Agreement. Here I just take the example of trademarks. On trademarks, the Bangui Agreement defines what is the matter, what is considered to be trademarks. It states what are the rights that are conferred. When your trademark is protected, it could be in Benin, in Togo, or in Cameroon, or in Congo. What are the rights that are conferred for the entire region? It gives the issuance procedure. So you have a procedure that is single and codified, which can be applied from one country across all other countries, or applied directly at the OAPI headquarters. I'm going to explain further how OAPI relates with the regional, with the national offices. So you have, this can run right up to conferring infringements, conferring procedures on how to appeal, on how to oppose a trademark. All of this are laid down in the Bangui Agreement, and the countries just have the responsibility to ensure that the enforcement systems are working. So what does OAPI do? As an organization, OAPI has to examine applications and issue properties. OAPI has to keep a special register. So OAPI also serves as the archival unit of all protected subject matter. That is why OAPI has what we call the Supreme Judicial Appeal Council, that is able to state what is protected, what is not protected, and to what extent. They also deal with documentation and information, and most importantly, to provide training. So OAPI also has a mandate to ensure that there is an increased and improved understanding of IP and IP-related issues across the region. So this is still a continuation of what I was saying, that OAPI has to encourage the respect of IP law among member states. OAPI also has, so it's a mission that goes just beyond setting the law. One, the countries have agreed on common law. And because IP issues are usually complex and need more schooling, OAPI has bring that the most respected. We are also going ahead to train and to improve the understanding of IP around these countries. So definitely you're asking yourself, how does this legislation in the 17 countries fits into the international system? Because that is also the crux of our discussion here. How do I ensure that my trademark, wherever filed, is respected in the OAPI region? One, OAPI, the Bangui agreement that we have spoken about, is consistent with the TRIPS, the World Trade Organization Agreement on trade-related issues of IP. So OAPI has a legal system that is compliant with the international legal system on IP. All of the countries in OAPI are also members of WIPO, the World Intellectual Property Organization. And OAPI itself as an organization is an accredited observer of WIPO and also a signatory to main treaties related to IP. What does this mean? This means that the region does not operate in some kind of a vacuum. The region operates in compliance with other international agreements on IP. And I use this opportunity to talk about the Madrid system and the Hague agreement. So OAPI is a partner to the Madrid system. OAPI is a signatory of the Hague agreement. Both mechanisms provide for the international registration of trademarks, and the Hague agreement provides for international registration and respect the governance of industrial designs. So if you file in an OAPI country, or you file from outside, once your rights are protected within the OAPI region, you have protection within the Madrid system and the Hague agreement. That's important. We'll be able to say one or two things after that when you come to questions. So I thought it was necessary after discussing this to give you a few tips. And for people who are seeking to enter any of these countries or to enter the region, there are a couple of things that you have to know. Despite this very structured legal system, which we must appreciate, there have also been issues related to counterfeit. It's a serious problem, and our project has been able to engage heads-on with regional partners and national offices, working on sensitization on fighting against counterfeiting. And I must say that it's a serious problem. So when you come into the region, one thing that we have noticed is that even after courts have passed judgment punishing acts of counterfeiting, it is sometimes difficult for companies to ensure that there is a reparation, to ensure that defaulters actually stop. So it's a continuous process. If you come into the region and you're a business, you're operating a business, one thing we advise is to ensure that we have good working relations with enforcement. Because you know that enforcement of IP in some countries around Africa, I would say most countries around Africa, is still a serious problem. Why is it a problem? Because sometimes it's a poor understanding. It's a poor understanding of why there should be enforcement, by the way. Because people are keen on ensuring that, okay, let's have the markets that have cheap goods, even if they're of low quality, even if they are counterfeit. And I like to say that, meanwhile, we accept that counterfeiting is a serious problem in the region. We also have to know that most of these counterfeited goods come from outside the region. They are produced elsewhere in the world, and they are brought to Africa. Because people understand that, okay, we want to have goods that are cheap, affordable, but of poor quality, counterfeit. So when you move into the region, there are a few things you must know. OAPI provides for what we call the national liaison offices. So the departments of intellectual property or industrial property in OAPI countries actually serve as liaison offices of OAPI and can be very useful either for filing applications or also for ensuring that rulings, judgments from the courts are actually applied. and that people can count on these agencies, can count on these departments to be able to serve as worthy relays of OAPI to ensure protection and greater protection. So when you file in one country, this is a good. You have a monopoly on using your title in all other countries. And finally, you could also aspire to an opposition procedure within the OAPI system if you imagine, or if you have proof that your rights are being violated, or that a name, a trade name or a trademark is being filed, which is a copy of what. So all of these procedures are possible, and OAPI actually provides for a smart system that is accessible through their website to be able to deposit the systems. So finally, I have a page here that I thought could be useful. So if you see eventually, I think we can be able to share this kind of material, but how to deposit within the OAPI region, for example. So you can file directly at the OAPI office in Yaoundé, or you can file through the 17 liaison offices that I have just discussed. So that's the same for patents, for trademarks, for designs, for commercial name. You can file directly at the OAPI office, or you can file through the OAPI liaison office, or even by post, because OAPI accepts filings by post. From outside the OAPI region, using the Framework on Patents Cooperation Treaty, the PCT, you can file through EUIPO. So there is a system, you file through EUIPO, and EUIPO is able to ensure that your application file is transmitted to OAPI in due course. For trademarks, based on the Madrid system, you can file through EUIPO. For designs, based on the Hague Agreement, you can also file through EUIPO. Duration of protection, for patents, you have 20 years from the first filing. For trademarks, you have 10 years from the filing, and this is renewable, of course, for trademarks. Designs, you have 5 years from the first deposit. This is renewable. For commercial names, you have 10 years. So who can file? Now, just like Nancy said, a company can file directly, but also, if you are out of the region, it could be advisable to use an OAPI mandated attorney. So OAPI has a group of attorneys who are accredited and who are allowed and authorized to file on behalf of foreign partners who are not able to be present physically in any of the 17 countries. So, ladies and gentlemen, I am going to stop there just to sum by saying that OAPI has a single system. The OAPI region has a single system, 17 countries with a single system serving as their national laws. And if you access one of these countries, you have protection for the entire region. There could be a little bit of pitfalls along the line, but when you have good advice, you can know how to go around this. Thank you, Javier. I'll be ready if we have any questions.
Thank you. It has been a very comprehensive intervention. I think that you have shared with us the main concepts on IP for the area. And I would like to ask you also about, because you have like a common piece of legislation, let's say the bank agreement, and how do you work in the consistency of the application of this legal framework? Could you give us some, some ideas about how are you working with the judges, for instance, on the predictability? No, because this is also important for the business to know.
Thank you, Javier. That is a key. Your question actually raises a key issue, because we have a single IP system, 17 countries, but now the laws are interpreted by local courts, and there have been issues in the past where plaintiffs imagined or thought that the courts were not having an unbiased interpretation of what is considered to be regional legislation. So, according to the Bangladesh Agreement, the local courts have a hierarchical preponderance on the interpretation of issues related to the Bangladesh Agreement. But now, OAPI also ensures that there is a certain level of consistency in the understanding of the main issues. I'll give you an example. I think sometime in 2016, there was a case in Cameroon that was brought against a foreign company. This is, I think, an Ivorian company was brought before Cameroonian courts against an Ivorian company for infringement. The case moved all through the instances, and at the level of the Supreme Court was ruled in favor of the Cameroonian company. But then the Ivorian company went back to Ivory Coast and filed again, claiming that the courts in Cameroon had ruled in some kind of a nationalistic tendency. Now, what OAPI does is to be able to circulate jurisprudence, court judgments, to ensure that all of the courts within the countries are informed that these are cases before these courts and these are the rulings. And even though OAPI cannot change rulings, but they can actually have a commentary, an annotation of the judgments to say that in the light of the law, because OAPI has this the Supreme Appeals Council, which can also issue commentary on the progress of IP law in the region. And it's interesting for me to use the opportunity to tell you that our project, the AfrIPI project, Africa Intellectual Property Rights and Innovation project, you see that's behind me, carried out the first ever meeting, some kind of a discussion of judges. These were mainly judges of commercial courts in all 70 OAPI countries. We met for 3 days in Abidjan, and it's interesting to see how the judges themselves are raising some of these issues. And one of the important outcomes of our meeting is the creation of an association of judges in the OAPI region, which is going to serve like some kind of a peer encouragement system. And also we want to put at their disposal a database of verdicts, judgments from around the region, so that they can rely on each other's experience, on each other's expertise to share this jurisprudence. I think this is one way in which that can be tackled. But summarily, I think that there has been a great measure of goodwill in the way the issues are handled, and OAPI too has been doing quite a lot to ensure that judgments are given, judgments are rendered to the best interest of the law and to the best interest of the parties. So I just thank you again. That was an important remark for me.
Thank you, Blaise. Crystal clear the effort you are doing and the capacity of, as Nancy was telling us, that you go very fast. Going back to Nancy, I have a question to you, and it's maybe it's also the cheetah that you were talking about within the context of an IP strategy, which is for you the relevancy of the importance of the flexibility,
Okay.
within this perspective, because it's important to be fast. It's important also to be flexible, but which is the order for you, or how to combine both of the approaches?
Thank you very much, Javier, for that very interesting question. I think it is important to build, agility, within and flexibility within your strategy. As I did mention, in the ARIPO region, unlike what my brother Blaise said in OAPI, ARIPO is individual countries with individual laws. So when you map up your strategy, I think the best thing is to make sure that you consider each country and then select how good it is for your business and for your plans and for your IP. And then once you've worked that out through the strategy, you then now move on to the next step of saying, how can I be flexible in terms of these states that I have chosen and in terms of the future states that I have not chosen? So you then incorporate your flexibility after the main strategy. Then once you've done that, you then now move with the agility and the speed. So to sum up, I would say in terms of order, you strategize first, and then you incorporate flexibility, and then you move with speed. And then I think that certainly gives you a more founded, perhaps, and a more credible way of moving around and navigating around the complexities that can arise within the ARIPO region because of these differences. Each country will interpret, ultimately, its IP laws territorially. And although, decisions of other countries may act as persuasive authorities, persuasion is not obligatory, so they are not a binding precedent. So I think that probably, I would say, in sum, is my view. I don't know whether I've answered you fully, Javier?
Thank you. Okay. We have more questions from the audience. We are more or less running out of time because we promised our audience 1 hour webinar. I think that it has been very fruitful. My impression is a personal one, is that we can go back to the motto of the webinar, and is that it's worth to file in Africa, no? And I think that this could be a good conclusion, because you gave us very good tips to approach, to our audience, to approach how to deal with IP in Africa, and the complexities, the simplicities that we can combine with the systems you have been talking about, and also that, as you said, it's a combination of different elements within the strategy that you have really very well explained to our audience. Sincerely, thank you again to both of you for your work, preparation of the webinar, the performance you did today. Thank you very much indeed to both of you. Have a nice day and a nice week, of course. Thank you.
Thank you very much.
Bye.
Bye.